Has honoured his brother Prince Edward in a most royal manner on his birthday. Fittingly, the King's younger brother was in Scotland on the day a new title was bestowed upon him, one that comes with the responsibility of...
Nobody saw this coming. Sophie completely falls apart the moment she finds out what Catherine has done. Edward spent decades being the good one, the loyal one, the quiet one. He never asked for anything. He never caused trouble. He did everything the palace asked. And now, the woman who married into this family has taken the one thing his own mother left him.
Was expected to join his family at an award ceremony at St James's Palace in London, but was unexpectedly absent after being struck down with a health issue. But Esther, what are your thoughts around this? Because royal experts say that this really would have been comforting.
The documents are real. The lawyers are real. The pain on Sophie's face is real. The palace wants this buried. They are praying you do not watch this video. King Charles III made an announcement in the spring of 2023 that was, on the surface, a straightforward piece of royal news. He named his youngest brother, Prince Edward, as the new Duke of Edinburgh. For most people watching from the outside, it looked like a touching moment. The title had been held by their father, Prince Philip, for more than 70 years, right up until his death in April 2021. Giving it to Edward seemed like the natural thing to do. Philip had reportedly wanted that outcome himself. The public largely received the news as a warm gesture from a new king to the brother who had always stayed loyal and kept a low profile. There were photographs, there were official statements, and then, as tends to happen with Edward, the story quietly faded from the front pages. What almost nobody understood at the time was that this moment, the granting of that title, was not the end of a sentimental story. It was the beginning of something much more complicated. The British royal family has a remarkable track record of surviving situations that would have ended almost any other institution. The abdication of King Edward VIII in 1936, when he gave up the throne to marry an American divorcee, shook the monarchy to its foundations, and yet the institution held. The very public breakdown of the marriage between Prince Charles and Princess Diana in the 1990s, played out in the press and eventually in separate television interviews, caused serious damage to the public image of the royal family, and yet the institution survived. The death of Diana in Paris in August 1997 triggered an outpouring of public grief so intense that the palace found itself badly out of step with the national mood, and still the institution found its footing again. The sexual scandal surrounding Prince Andrew, whose friendship with the convicted sex offender Jeffrey Epstein resulted in a lawsuit, a settlement, and the effective end of his public royal career, was perhaps the most damaging chapter in recent memory, and yet the institution absorbed it. And then there was the departure of Prince Harry and his wife Meghan, who stepped back from senior royal duties in early 2020, relocated to the United States, and proceeded to give a series of interviews and produce a documentary series that aired very personal grievances about how they had been treated inside the palace. Even that, as dramatic and damaging as it was, did not fundamentally alter the structure of the monarchy. What is unfolding now, however, is different in character from all of those episodes. The earlier crises were primarily about people, about personal decisions, personal relationships, personal failings, and personal grievances. They were emotional, and they were human, and they played out in the press and in the court of public opinion. The current situation is not primarily about people. It is about documents. It is about what was written down, what was signed, and what the law says those signatures mean. And that distinction matters enormously, because emotions can be managed and personal conflicts can be smoothed over, but legal documents are harder to negotiate with. At the center of what is now developing is a legal dispute, a serious one, involving significant sums of money and the kind of lawyers who deal in significant sums of money. The argument, broadly stated, is that King Charles III, in the months following the death of Queen Elizabeth II in September 2022, made decisions about certain royal assets, decisions involving the management and direction of income and property, worth potentially tens of millions of pounds, without fully accounting for the legal rights that had already vested in his youngest brother at the moment the Edinburgh title was formally transferred to him. Edward's legal team have confirmed in writing that specific entitlements attached to the Dukedom of Edinburgh were legally his from the point the title was granted. and that those entitlements do not appear to have been properly recognized in the decisions Charles subsequently made about the relevant assets. This is the kind of claim that, if it lacks substance, gets dismissed quickly and publicly. Institutions with powerful legal departments do not stay silent when faced with a challenge they can easily defeat. They issue statements, they set the record straight, they move on. The palace has not done that. Instead, the response has been careful, measured, and notably quiet, which tells its own story. The institution that now finds itself in this position is one of the oldest and most established monarchies in the world. The British royal family traces its modern lineage back through generations of carefully managed succession, accumulated wealth, and the kind of institutional memory that allows it to navigate almost anything. It has departments dedicated to legal affairs, estate management, and public communications. It has access to some of the most experienced legal minds in the country, and yet it appears to have found itself on the back foot in a dispute not with a foreign government, not with a commercial rival, not with a campaign group or a newspaper, but with its own youngest prince. That youngest prince is Prince Edward, who was born in 1964 as the fourth child of Queen Elizabeth II and Prince Philip. He is now the Duke of Edinburgh, a title that carries one of the most layered and historically significant legal histories in the British peerage. He is also, by most accounts, the member of the royal family that the press and the public have found the least interesting over the past 3 decades. That is not an insult. In the context of what is now happening, it turns out to be one of the most significant things about him. Edward has never been the kind of royal who generates headlines through personal drama. He left a Royal Marines training program in 1987 before completing it, which was written about at the time and then largely forgotten. He spent some years working in television production through a company called Ardent Productions. He married Sophie Jones in 1999 in a ceremony that was notably quieter than the high-profile weddings of his siblings. He carried out his royal duties consistently and without incident. He did not give the kind of interview that shifts the public conversation. He did not become associated with the kind of controversy that defines a public reputation for years. He was, in the most straightforward sense of the phrase, a working royal who did the work and stayed out of the news. For a long time, that meant he was overlooked. The press had very little to write about when it came to Edward, and so it largely did not. The public, faced with the far more dramatic stories of Charles and Diana, Andrew and his various controversies, and eventually Harry and Meghan, had very little reason to pay close attention to the quiet brother who showed up, did his engagements, and went home. What that long period of being overlooked also meant, though, is that Edward was watching. He was in a position to observe over many years exactly how the institution operated, where the formal structures were solid and where the assumptions that held things together were perhaps less carefully examined than they should have been. He had time, and he had access to his mother, and at some point he or those advising him appear to have understood something about the title she gave him that the palace itself had not fully processed. What Queen Elizabeth handed her youngest son in June 2022 was not simply a name and a set of ceremonial responsibilities. It was, according to the legal argument now being made on his behalf, something considerably more substantial than that. To understand why the granting of the Dukedom of Edinburgh to Prince Edward in 2022 carries the legal weight it now appears to carry, it helps to start not with Edward himself, but with the title. Because the Dukedom of Edinburgh is not a straightforward piece of royal nomenclature, it has one of the more complex and layered histories of any title in the British peerage, and that complexity is not incidental to the current dispute, it is central to it. The dukedom has been created, allowed to lapse, and reconstituted multiple times over the centuries. Titles of this kind, particularly those associated with significant royal figures, often accumulate legal history with each iteration. Each time a title is best formally created or recreated, it is done through a legal instrument called letters patent. These are not informal documents. They are carefully drafted legal texts, prepared by qualified legal counsel, and they set out in precise terms what the title is, who holds it, and what rights and obligations attach to it. The specific content of those instruments matters because it is the instruments that have legal force, not the ceremony surrounding them. The most recent and most relevant chapter in the history of the Edinburgh dukedom began in 1947. King George VI, who was at that point the reigning monarch and the father of Princess Elizabeth, the heir to the throne, granted the title of Duke of Edinburgh to a young naval officer named Philip Mountbatten on the occasion of his marriage to Princess Elizabeth. Philip was born into the Greek and Danish royal families, but had served in the British Royal Navy during the Second World War and had become a naturalized British subject. That's you. Granting of the Edinburgh title marked his formal incorporation into the British royal family. It would be easy to look at that moment and see it primarily as a sentimental gesture, a father welcoming his new son-in-law with an appropriate title for the occasion. There was certainly an element of sentiment to it, but the letters patent that formally established the dukedom were not drafted with sentiment as their primary purpose. They were legal documents, constructed with care, and they contained provisions that went well beyond simply attaching a name to a person. They set out what the title carried, what rights, what entitlements, and what charges or obligations attached to the dukedom itself, as distinct from the individual who happened to hold it at any given time. That distinction between what belongs to the person and what belongs to the title is one of the foundational concepts in the law of royal grants, and it would become critically important more than 7 decades later. Philip held the dukedom of Edinburgh for the rest of his life. He died in April 2021 at the age of 99, just a few months before what would have been his 100th birthday. When he died, the title entered what is known in peerage law as abeyance. Abeyance is a formal legal status, not a vague administrative limbo. It means the title continues to exist as a legal entity, but currently has no holder. This happens routinely when a title held by a royal consort reverts to the crown upon that consort's death. The crown then has options. It can allow the title to remain in abeyance indefinitely. It can formally extinguish it, or it can re-grant it to another individual. The decision about which of those paths to take rests with the sovereign. Queen Elizabeth II, in the period following Philip's death, made her intentions clear. Within royal circles and eventually in public reporting, it became understood that she intended the Edinburgh title to pass to her youngest son, Edward. This was not a surprise to those close to the family. Philip himself had reportedly expressed the wish that Edward would eventually receive the title. The Queen shared that wish. She wanted someone she trusted to carry the dukedom forward, to hold it with the same sense of duty and dignity that had defined Philip's tenure. It was a deeply personal decision rooted in the specific character of her youngest son, who had throughout his adult life demonstrated exactly the kind of quiet reliability that such a wish implies. The formal moment came in June 2022, during the celebrations marking the Queen's Platinum Jubilee, her 70th year on the throne. On that occasion, Elizabeth made it official. Edward and his wife Sophie were formally styled as the Duke and Duchess of Edinburgh. For most observers, it was a moving footnote to the Jubilee celebrations. A mother honoring her late husband's memory by ensuring his title passed to the son who had most consistently embodied the values Philip had stood for. The coverage was warm and relatively brief, and then the news cycle moved on. What the coverage did not fully examine, and what the palace itself may not have examined with sufficient care, was the precise legal mechanism by which the title was transferred, and what that mechanism meant in practice. Because when Queen Elizabeth formally re-granted the Dukedom of Edinburgh to Edward, she was not simply reassigning a label. Under the legal architecture established by the 1947 letters patent, and under the associated instruments that had accumulated during Philip's more than 7 decades as Duke, the transfer of the title carried with it a set of legal entitlements that were tied to the dukedom itself, rather than to Philip as an individual. This is the point at which the legal argument becomes technical, and it is worth taking a moment to understand the distinction being drawn. In English property law, and in the law governing royal grants, there is a meaningful difference between rights that belong to a person and rights that attach to an office or title. Rights that attach to a title travel with it. They do not dissolve when one holder dies, and they do not restart from zero when a new holder is named. They persist. They follow the title through each transition from one holder to the next. The legal term most commonly associated with this concept is a charge or encumbrance on the relevant interest. A charge of this kind binds whoever holds the encumbered asset or title, regardless of how they came to hold it. Edward's legal team, who began a detailed and methodical review of every relevant document in or around 2023, found what they describe as provisions of exactly this character embedded in the instruments surrounding the Dukedom of Edinburgh. provisions drafted deliberately, constructed with legal precision, and carried forward through the decades of Philip's tenure. Provisions that, on a careful reading of the applicable law, did not simply dissolve when Philip died, and did not reset when the title was regranted to Edward. They survived the transition. They attached to the dukedom as Philip had held it, and when that dukedom passed to Edward, they came with it. The review that produced this conclusion was not a quick one. It involved working through the original letters patent from 1947, the trust instruments associated with the dukedom, the estate planning documents accumulated over Philip's long tenure as duke, and the specific legal instruments surrounding the formal transfer of the title to Edward in 2022. That is a substantial body of material, covering more than 70 years of legal history, and combing through it with the level of precision required to identify enforceable provisions takes time and expertise. Edward's legal team appear to have brought both. What they found, when they completed that review, was a set of entitlements relating to specific property interests and income streams that they concluded were legally his from the moment the Queen's grant took effect. Not courtesy entitlements, not the kind of informal arrangements that depend on the goodwill of whoever happens to be managing the relevant assets. Legal entitlements, documented and binding, of the kind that exist within the framework of English property law, and that English property law, in principle, enforces regardless of the seniority or constitutional position of the person on the other side of the argument, even if that person is the King of England. That conclusion, once reached and confirmed in writing by qualified legal counsel, created a situation that the palace was not prepared for, because it meant that decisions had already been made, significant decisions involving significant assets that had not accounted for rights that were already in place. And it meant that the person holding those rights, the quiet brother, the one the institution had never felt it needed to worry about, had the documentation to say so. To appreciate the full weight of what Edward's lawyers found, it is necessary to understand something about how royal property actually works, because there is a widespread assumption that all royal assets operate under the same rules and are equally beyond the reach of ordinary legal challenge. That assumption is not correct, and the distinction between different categories of royal property is not a minor technical detail. It is the foundation upon which the entire legal argument rests. The properties that most people associate with the British royal family fall into two broad categories, and those categories are governed by entirely different legal frameworks. The first category includes places like Buckingham Palace and Windsor Castle. These are crown properties held by the monarch in right of the crown. What that means in practical terms is that they belong to the institution of the monarchy rather than to any individual who happens to be its head. No sovereign can sell them, leave them to someone in a will, or treat them as personal assets. They exist independently of whoever is wearing the crown at any given moment, and they are governed by a constitutional framework that sits largely outside the reach of ordinary property law. The second category is different in almost every relevant respect. Balmoral Castle in Aberdeenshire and Sandringham House in Norfolk are not crown properties. They are privately owned estates that have been held and passed down within the royal family as personal assets. Balmoral was purchased outright by Prince Albert, the consort of Queen Victoria, in 1852. Sandringham was acquired by the then Prince of Wales, who would later become King Edward VII in 1862, paid for from his own income as a private residence. Both properties have remained in private hands ever since, passed from one generation to the next through private bequest rather than constitutional transfer. That private status matters enormously. Private property, unlike crown property, exists within the full reach of ordinary English property law. It can be encumbered. It can be subject to charges and documented provisions that survive the death of one owner and bind whoever acquires the asset next. It can carry entitlements that attach to a title or office associated with the property and travel with that title when it changes hands. And crucially, ordinary English property law does not create special categories of exception for people based on how prominent or powerful they are. A charge that attaches to a private estate binds the next owner of that estate, whether that owner is a private individual, an institution, or a king. Queen Elizabeth II's will, like all royal wills, is sealed from public scrutiny. That convention has been in place for some time and was reinforced following legal proceedings in 2021 that sought to make Prince Philip's will public. The specific provisions of the Queen's testamentary arrangements are not publicly known. However, the instruments that surround a will, trust deeds, estate planning documents, provisions attached to specific titles and offices, are not entirely invisible to a legal team that has been formally authorized by the relevant title holder to examine them. And it is within those surrounding instruments, rather than the will itself, that Edward's lawyers appear to have found the provisions at the center of their argument. What those provisions reportedly set out, on a careful legal reading, are entitlements belonging to whoever holds the dukedom of Edinburgh at any given time, not entitlements that were personal to Philip and expired with him, not entitlements that the crown could simply absorb or redirect after Philip's death and before the title was regranted. Entitlements tied to the dukedom as an office, covering specific interests in certain estate properties and income streams generated by those properties. In at least one documented case, the legal instruments apparently establish what is described as a reversionary interest, a formal legal right that attaches to a property interest and follows it, rather than dissolving when circumstances change. That is not a vague aspiration or a moral claim. In English property law, a reversionary interest is a recognized and enforceable legal right. The practical implication of that argument, if it holds, is significant. It means that when King Charles III moved to consolidate the royal portfolio under his authority in the months following his mother's death in September 2022, he was making decisions about assets that were not entirely his to decide about unilaterally. The decisions Charles made were not unusual for a monarch in the period immediately following succession. Sovereigns throughout history have taken steps to assert control over the royal estate, restructure management arrangements, and ensure the financial operation of the institution runs efficiently under new leadership. Charles moved with what those familiar with the situation have described as characteristic efficiency. He made significant decisions about the management of Sandringham, including changes to how income from its agricultural operations and commercial holdings was directed. He made decisions about the long-term management of Balmoral, including choices relating to forestry operations, the use of satellite properties on the estate, and future planning. He consolidated certain income streams under the Duchy of Lancaster, which is the financial vehicle associated with the sovereign. These were serious decisions involving assets worth, by various estimates, somewhere between 50 million and several £100 million. And according to those familiar with Edward's legal position, they were decisions made without the palace's legal operation pausing to ask a question that, in retrospect, appears to have been essential. Did the new Duke of Edinburgh have a documented and legally enforceable stake in any of this? The answer that Edward's lawyers delivered, formally and in writing, in late 2023 or early 2024, was yes. The provisions they had identified in the surrounding instruments were not ceremonial. They were not the kind of loosely worded aspiration that a competent barrister could dismiss in short order. They were carefully drafted provisions with the weight of English property law behind them, and they had vested in Edward at the moment the Queen formally transferred the dukedom to him in 2022, which meant that by the time Charles had completed the consolidation of the relevant assets, he had done so in a way that his youngest brother's lawyers could credibly argue was legally premature because it had not accounted for rights that were already in place. The formal communication of that position to the palace was, by all accounts, conducted with the kind of precise professional language that serious legal correspondence demands. It was not a threat in the aggressive sense. It was a statement of legal position, documented and supported, delivered through appropriate channels. But the substance of what it said was unmistakable. The palace had made assumptions about these assets that the documents did not support, and the person those documents protected was now in a position to say so. The palace's response to receiving that communication has been, in its own way, more telling than anything that has been said publicly. Because nothing has been said publicly. The instinct of a confident institution facing a claim it believes to be without merit is to address it directly, clearly, and without hesitation. The palace did not do that. Instead, it went quiet in a way that experienced observers of the royal family noted as unusual. The normal background activity of the palace communications operation, the careful briefings to trusted journalists, the subtle management of narratives before they could develop momentum, was conspicuously absent on anything touching Edward's financial position or the management of the relevant estates. Institutions that are confident do not operate that way. Behind the public silence, three things appear to have happened in parallel. The first was negotiation. Representatives of King Charles and Prince Edward have reportedly been engaged in a series of careful and formal legal exchanges. Not family conversations aimed at resolving a misunderstanding, but structured discussions between legal teams about what the documents say, what the entitlements amount to, and what accommodation might be appropriate in light of that. The second was the palace conducting its own urgent legal review, quietly and without announcement, re-examining the very instruments and provisions that it had previously treated as settled matters. That kind of internal scramble for legal reassurance does not happen when an institution is confident in its position. It happens when someone has handed that institution a document that has introduced genuine uncertainty. The third development is harder to quantify, but has been noted by those who follow the royal family closely. The visible relationship between King Charles and Prince Edward has shifted in a way that is subtle but perceptible. There have been fewer joint public appearances. The easy, relaxed quality that cameras use to capture in their interactions has been less evident. Edward and Sophie have continued to carry out their royal duties with the same consistency they have always shown, and neither party has said anything publicly that could be interpreted as a signal of tension. But something in the atmosphere between them has changed, in a way that those paying attention have found difficult to ignore. When two people are in the middle of a serious legal negotiation, and when the wrong public word could have real legal consequences, they tend to be careful. That carefulness has a quality that is recognizable to anyone who has seen it before. It does not look like everything is fine, because everything is not fine. To understand why this dispute matters beyond the immediate parties involved, it helps to start with the money, because the sums being discussed are not trivial, and the assets at their center are not obscure footnotes in the royal portfolio. They are two of the most recognized and historically significant private estates in Britain, and the question of who holds legally enforceable rights over them, and over the income they generate, is a question with real and substantial financial consequences. The Sandringham estate in Norfolk covers approximately 20,000 acres of countryside in the east of England. The main house, Sandringham House, is familiar to most British people as the place where the royal family traditionally spends Christmas and where several significant moments in royal history have taken place. But the house itself is almost incidental to the economic reality of the estate as a whole. Sandringham encompasses a large portfolio of working farms, managed woodland, commercial agricultural operations, and a range of other property interests. It generates substantial annual income from farming activity, game and wildlife management, and visitor attractions open to the public at certain times of year. Estimates of the total value of the Sandringham estate vary depending on the methodology used and the economic conditions at the time of assessment, but credible figures place it somewhere between 50 million and 200 million pounds. That is a wide range, but even at the lower end of it, the sums involved are significant by any standard outside the very highest levels of private wealth. The Balmoral estate in Aberdeenshire is larger still. It covers approximately 50,000 acres of Scottish Highland, and in addition to the castle itself, it includes a number of smaller residential properties, grouse moors that generate income through sporting leases, commercial, forestry operations, and productive farmland. Its estimated value, by most serious analyses, runs well above 100 million pounds. Like Sandringham, it is private property, privately managed, and subject to the full framework of ordinary English and Scottish property law, rather than the separate constitutional framework that governs Crown estate assets. Both estates were privately bequeathed by Queen Elizabeth II. Both carry sealed provisions that the public has never seen. Both are, on the legal argument now being advanced by Edward's team, encumbered by entitlements that vested in the current Duke of Edinburgh the moment the title was formally transferred to him. And both have been managed since the Queen's death in September 2022 in ways that, according to those familiar with Edward's legal position, did not account for those entitlements. When you add to those estate interests the financial provisions that can attach to a title of this historical significance, annuities tied to specific peerage titles, trust interests accumulated over decades, income entitlements that under the right legal instruments follow a dukedom from one holder to the next, the total potential value of what Edward's lawyers say was not properly accounted for could, by some estimates, run into the tens or even hundreds of millions of pounds. It is important to be precise about what Edward's legal position does and does not involve, because there is a version of this story that is easier to tell but less accurate. Edward is not claiming the throne. He is not challenging the line of succession or positioning himself as any kind of rival to his brother. He is not attempting to relitigate the constitutional foundations of the monarchy or to undermine the institution in the way that the departure of Harry and Meghan was perceived by many to have done. There is no book being written about this. There is no documentary crew. Edward has not spoken publicly about any aspect of the dispute and, by all accounts, has no intention of doing so. What his legal team is arguing is both more narrowly focused and more consequential than any of that. They are arguing that specific provisions, documented and legally binding provisions, attached to the Dukedom of Edinburgh as it was constituted by the 1947 letters, patent, and as it was formally re-granted to Edward by Queen Elizabeth II in 2022, give the current Duke of Edinburgh enforceable rights over specific property interests and income streams, rights that do not depend on the goodwill of the monarch, rights that survive the death of the previous holder and reattach when the title passes to someone new, rights that exist within the framework of ordinary English property law, and that English property law, in principle, enforces regardless of the rank or constitutional position of the person on the other side of the dispute. The legal concept at the heart of this argument is the question of whether those provisions constitute what is known in English property law as a binding charge or encumbrance on the relevant interests. A charge of this kind is a legal obligation that attaches to a property or asset rather than to a particular person. It follows the property. It binds whoever acquires the encumbered asset next. It cannot simply be set aside or absorbed by an incoming owner without first acknowledging and accounting for the rights it creates. If the provisions Edward's lawyers have identified are indeed of this character, and their formal written confirmation suggests they believe they are, then the argument is that those rights could not simply be treated as though they did not exist when Charles made his decisions about the relevant assets in the months after the Queen's death. They were already in place. They had already vested. And whoever managed those assets was bound by them, including the king. The palace's response to all of this has already been discussed in terms of what it revealed about the institution's confidence in its own position, but the broader implications of where this dispute goes next deserve careful consideration, because the possible outcomes extend well beyond a private disagreement between two brothers over an inheritance. The most probable outcome, and the one that the palace's behavior most strongly points toward, is a quiet settlement reached behind closed doors. This is consistent with how the British monarchy has historically preferred to deal with uncomfortable internal realities. The institution has a long-established practice of resolving difficult situations through private negotiation, in ways that allow it to maintain the outward appearance of unity and continuity, while making whatever internal adjustments the situation actually requires. In this scenario, Edward's legal position would be acknowledged in substance, even if not in explicit public terms. Some form of structured accommodation would be reached, perhaps a formally recognized income, arrangement tied to specific estate interests, perhaps a restructured set of management provisions for the relevant assets, perhaps a combination of the two. The public statement, if there is one, would be warm in tone and entirely uninformative about the specifics. Edward and Sophie would continue their royal duties. Charles would continue to reign. And somewhere in the records of a very discreet law firm, there would be documentation of an agreement that acknowledged, in the careful language that lawyers use when they want to say something without quite saying it, that the initial assumptions about those assets were not fully supported by the legal instruments governing them. Even that outcome, the quietest and most contained version of events, carries significance. A private settlement is not a dismissal. It is an acknowledgement that the legal argument was serious enough to engage with, to negotiate over, and ultimately to resolve by making real concessions. It means that a reigning monarch was presented with a legal position that said his decisions about specific assets had not properly accounted for his brother's rights, and that rather than simply rejecting that position, he found it necessary to address it. That is not nothing. That is, in fact, quite a lot. The second possible trajectory is formal legal proceedings. and while it is considerably less likely than a settlement, it cannot be ruled out entirely. If negotiations break down, if the sums involved prove too large to resolve through informal accommodation, or if positions on either side harden to the point where compromise becomes impossible, this dispute could move into the courts. That would be an extraordinary development. Royal family members have resorted to litigation before, but rarely, and the instances that have occurred have caused lasting reputational damage to the institution. A formal legal dispute of this kind would require at least partial disclosure of instruments that the palace has always treated as private. It would unfold in public with full media attention, and it would require the application of ordinary property law to the specific provisions of royal letters patent in a way that has no real modern precedent. The reputational consequences for the monarchy would be severe, and the practical consequences for the palace's ability to maintain its customary opacity about how it manages its assets would be equally serious. That combination of factors makes settlement almost certainly the preferred outcome for everyone involved. But the existence of a credible legal argument strong enough to bring the dispute to this point is itself significant, because you do not negotiate seriously with a position unless you believe that position has genuine force behind it. The third possible outcome is in some ways the most far-reaching, and it does not depend on how the immediate dispute between Charles and Edward is resolved. It is the possibility that this situation, whatever its private conclusion, triggers a broader and more sustained scrutiny of how royal property rights are documented, managed, and legally protected. Constitutional scholars who have been following these developments have noted that the questions raised by Edward's legal argument extend well beyond the Edinburgh dukedom specifically. They raise questions about whether the legal instruments governing royal property arrangements across the board have been maintained with sufficient rigor over the decades. They raise questions about whether the palace's internal legal operation, which has historically functioned with a level of opacity that it justified through tradition and the particular constitutional position of the monarchy, is properly equipped to handle the kind of determined and methodical legal challenge that Edward's team has mounted. And they raise questions about whether Parliament, if it becomes sufficiently aware of what this dispute has exposed, might choose to pay closer attention to how private royal estates are managed, and on what legal basis the decisions made about them rest. Parliamentary attention is not easily redirected once it has been attracted. The management of private royal estates has operated with considerable opacity for generations, and that opacity has largely gone unchallenged because nobody with both the legal standing and the resources to challenge it had previously chosen to do so effectively. Edward's legal team may have just demonstrated that it can be done, that the instruments governing these arrangements are subject to examination by qualified counsel, that someone with the right title, the right documents, and the right lawyers can bring a serious legal argument to bear, even against the most powerful individual in the country. If that is established, even privately, even through a settlement that never becomes fully public, it becomes considerably harder for the palace to argue in future that scrutiny of how it manages its assets is inappropriate or beyond the reach of ordinary law. Prince Edward has spent the better part of 4 decades cultivating a public image built on studied reliability and a near-total absence of drama. He showed up. He did the work. He stayed out of the headlines. While his brothers generated controversy in their various ways, Edward generated almost nothing, which meant almost nothing was written about him, and almost nothing was expected of him. The institution appears to have concluded over many years that he was the one it did not need to think about very carefully. That assumption now looks like it may have been the most consequential mistake the palace made during that entire period, because while it was not thinking carefully about Edward, it turns out, was thinking very carefully about everything else. And the letter his lawyers eventually wrote, formal and precise, and grounded entirely in what the documents actually say, landed in the palace, with the weight of decades of quiet observation behind it. The question of where things go from here is one that neither the palace nor the public has a complete answer to, yet. But the fact that the question is being asked at all tells you something important about how much has already changed.